Hi, good morning or good afternoon. Thank you for joining us for this webinar on AT and the IEP. My name is Loni Allen, and with me today is Dianah Marr. We both work in the education department as education specialists at Parents Helping Parents in San Jose, California. Next slide. We'd love you to visit our website and cruise around a little bit in there, click on some of the pages, and find out a little bit about what the scope of our agency does. Each Parent Training and Information Center has their unique supports and services, but we all provide support about educational rights to families and professionals who contact us with questions. We're a federally funded Parent Training and Information Center covering San Joaquin, San Mateo, Santa Clara, and Santa Cruz counties in California. And each state has at least one PTI, but because California is so large, we have many. So you can find the PTI in your area by clicking on the link at the bottom of the slide. PHP provides an array of services to families and professionals that contact us, including a library, family and community resources and information, support parents, support groups. We have an education department, trainings, one-to-one support, phone support, an iTech department with information and training about assistive technology, and much more. Next slide, please. Our objective today is to provide a very basic overview of special education, including consideration of assistive technology. We encourage you to attend a more in-depth training about special education at your local Parent Training and Information Center. We also would like to encourage your participation and questions. If you enter your questions in the chat box, until we get connected, I'm sure Shannon can read questions to us as we go along in the training, and we'd be happy to address them as they come along. Next slide, please.
On this slide, there is a photo of two young high school graduates holding a cake in celebration. An IEP is an Individualized Education Program. A written document is developed for each public school child who is eligible for special education. This document must meet a child's unique needs, including any need for assistive technology, low-tech, high-tech, and services. This law provides for services for eligible children from birth through high school graduation with a diploma or through the age of 21. What is written on this slide is the foundation upon which all of the law is based. Part B of IDEA covers school-age children age 3 through 21. Next slide, please. All right, on this slide, we'll discuss the basic 6 rights in IDEA. A free and appropriate education mandates education at no cost to the family. Each child with disabilities must receive a complete, non-discriminatory educational assessment. Eligible children must be considered to be reevaluated at least every 3 years. The IEP is a focused set of goals and services which addresses each student's individual educational needs. Here's a tip. Always ask yourself at any point of assessment, is assistive technology an area that needs to be included in the assessment? The IEP must be reviewed by the IEP team at least once a year to update the goals. It is a legally binding document that services written into an IEP will be provided. The promise of parental involvement guarantees parents' involvement throughout the entire IEP process. In addition, procedural due process procedures guarantee parents and the school district the option of appealing decision-making procedures where the two parties cannot reach agreement. Next slide. There is a photo on this slide of children in a classroom. FAPE is what states must make available to all eligible students with a disability. If you break the definition, down, you'll see there are 6 components. FAPE includes these 6 ideas. The first is special education and related services. The second is it's free to families, provided at public expense. And thirdly, it should be supervised and directed by a public agency. And fourth, based on the standards of the education system. And fifth, provided in an appropriate preschool, elementary school, or secondary school in the state. And lastly, provided in accordance with an appropriately developed IEP. Next slide.
The process of determining eligibility begins with a referral for comprehensive assessment for special education. As you can see in this slide, either the parent or the school may request assessment. Parents and others making the referral can indicate if they feel the child may require assistive technology and assessment in that area. We encourage parents at all of our trainings to put their concerns about their child in writing. The PHP website has a letter template that can help you formulate a letter to request assessment, and the link to that template is on the slide at the bottom of the slide. If you have additional information to share with your team at school, such as private assessment or success in the use of technology, it's useful to share that information. Then the team will know that your child's already trialed some equipment and they may incorporate it into their assessment. Next slide. On this slide, it's about the California Special Education Cycle, and at the top of the slide there's a photo of a calendar page. When a parent makes a written request to the school district to assess their child to see if they are in need of special education, the school district must respond within 15 calendar days, either with an assessment plan or with written notice as to why the child does not need to be assessed. Most school districts invite the parents to a student study team meeting, or sometimes it's called a child study team meeting, to have a discussion with the appropriate individuals from the school about the concerns about the child. If the school is not required to reevaluate a child more often than once a year, unless the parent and the school agree otherwise. The school shall evaluate at least every 3 years, unless the parent and the school agree together in writing that a reevaluation is unnecessary. Keep in mind that assistive technology assessment may be part of any evaluation if it's felt this is an area of need for a student. Before signing your assessment plan, parents are wise to check to see if this area of need has been included on the assessment plan explicitly, and ask questions if you notice that it's not there. Next slide. This slide has a photo of students in a classroom sitting at their desk. Know that by conducting the evaluation, each school district needs to use a variety of assessment tools and strategies to assist the IEP team in determining if the child is a child with a disability and determine what should be included in the content of the child's IEP if they're found eligible. And the schools may not use any single measure or assessment as the sole criterion for determining whether the child is a child with a disability or in determining an appropriate educational program for the child. Also, they must use technically sound instruments that may assess the relative contribution of cognitive and behavioral factors in addition to physical or developmental factors. Information that is provided by parents must also be considered, so parents are wise to share with them information about the child's disability or medical diagnosis. And now, Dianah, would you introduce something about Section 504? And next slide.
Sure, Loni. On this slide, there is a photo of some children in class raising their hand. So what is a 504 accommodation plan? Section 504 is part of the Rehabilitation Act of 1973 that prohibits discrimination based upon a documented disability. Section 504 is an anti-discrimination civil rights statute that requires the needs of students with disabilities to be met as adequately as the needs of the non-disabled are met. So a 504 accommodation plan may be developed for a child who is not enrolled in special education but who requires accommodations or modifications during the day. A 504 accommodation plan should be used in the school to support the needs of a child who does not have an IEP. For example, this might include a child with diabetes, cystic fibrosis, nutrition needs, metabolic disorder, anxiety, or any documented disability that does not reach the level of severity for special education services required under the IDEA. In the case of a child classified under Public Law 504, only accommodations and/or modifications are provided by the school. So what is the definition of Section 504? It says that no otherwise qualified individual with a disability in the United States as defined in the section of the title shall solely by reason of her or his disability be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. And this includes public schools and programs. Next slide, please. So eligibility under 504 is based on the impairment or disability. So it includes any disability, long-term illness, or various disorders that substantially reduces or lessens a student's ability to access learning in the educational setting because of learning, behavior, or health-related condition. So there is a difference between an IEP and a 504 accommodation plan. IEP plans include the 504, cover the 504 rights. So students who don't qualify for an IEP should have a 504 accommodation plan written independently so that all providers understand explicitly what is to be provided for the child. Next slide, please.
So now we're on the slide eligibility for special education. The eligibility for special education is based on the results of the assessment presented to the IEP team and usually completed by the school district, as well as the consideration of any outside assessment a parent may provide. Standardized assessments alone can't be the basis for establishing or denying eligibility, and therefore the district and the rest of the IEP team must consider class grades, portfolio evaluation, observation, information, classroom performance and behavior, as well as information that parents provide that can all be indicators that a child's disability is impacting his or her ability to learn. Also, functional assessments in the school setting, in the home setting, or community setting, or for the child's need for assistive technology and the settings in which it would be used. Upon completion of the assessments, the determination of whether a child is a child with a disability and the educational needs of the child is to be made by a team of qualified professionals and the parent of the child. A copy of the evaluation report and the documentation of determination of eligibility is to be provided to the parent at no cost. Next slide. On this slide, there's a photo of a boy that's sitting in a wheelchair, and he looks really happy. And you should know that to be eligible for special education services between the ages of 3 to 21, a child has to fit in one of the 13 named disability categories. And in California, there's an additional category, only in California law, called established medical disability. Next slide, please. So this slide is a little bit about getting ready for the IEP team meeting. And if you're a parent, you should ask yourself, were you informed ahead of time of who will be attending your IEP team meeting, and the purpose of the meeting, and the location and the time? Did you receive your written notice of meeting? In California, if you plan to tape record the meeting, you must let the school district know a minimum of 24 hours in advance. If you're in another state, some states aren't able to actually record the meeting, and you should check with your local parent training center to find out, or your State Department of Education, or your school district to find out what the rules are in your state about recording. If your child has trialed or currently uses any assistive technology, parents can share that information with the IEP team for consideration. In fact, you can bring your student with you and the technology and have them talk to the team about what their experience has been. Before leaving the meeting, be sure all the items on your parent agenda have been appropriately discussed and considered. The link on this slide is to a PHP IEP prep tool. It's a little bit of software where you click on the link and it walks you through being completely prepared for your IEP team meeting, and it can be useful in helping you prepare for your next meeting. So be sure to try that link out in preparation. Next slide, please.
On this photo, you will see, or on the slide, you will see a photo of the number 5 pinned to a wall, like a calendar. So let's address the parent right to school records. It is helpful to review your child's records. In California, the parent shall have the right and opportunity to examine all school records of the child. So with oral or written notice, the school district will provide a copy of the school records in 5 business days, at least in California. If you live outside California, check with your state laws and regulations for your timeline. Next slide, please. On this slide, you will see a photo of 2 women and a man at a meeting. As you can see on the slide, there are some required members of the IEP team, and parents should know they may invite other individuals who have knowledge or special expertise regarding the child, including related services personnel as appropriate. Also, the parent or the school may, if appropriate, invite the child with a disability. The student must be invited to attend beginning at age 14 in order to plan for the transition. Many parents find that including their student in the IEP helps keep the meeting focused on the needs of the student and is part of the student's learning in self-advocacy. Next slide, please. On this slide, there is a graphic of people at an IEP team meeting. Parents and schools may agree to use alternative means of meeting participation, such as video conferences and conference calls. Next slide, please.
At each initial IEP, annual IEP, and any meeting in which the assessment for AT is on the agenda, there's a consideration made of the child's need for assistive technology. As you can see in the slide, an AT device may be an item, a piece of equipment, a product system, and it is used to increase, maintain, or improve the functional capabilities of an individual with a disability. Next slide, please. I have some questions to review before I cover this slide. I wanted to go back to the evaluation process, and I want to give you some questions that parents can ask the school staff about evaluation. Why do you want to evaluate my child? What do you think you might find in the evaluation? What types of assessment or test will you be giving? In what areas will my child be tested? Will the test you use discriminate against my child based on race, culture, disability, use of language? How do you know that the tests do or do not discriminate? And what will happen if my child is not evaluated? Will she still get some help for the problems you identify? And by what date will you give me a written copy of the evaluation results so I can prepare for the IEP team meeting? And what steps can I take or should I take if I don't agree with the evaluation results? Now I'm going to move on to the slide called IDEA 2004. And on the slide, there's a photo of two adults with a preschool-aged child sitting and using a piece of technology. Assistive technology is also a service that assists an individual with a disability in selection, acquisition, or use of an AT device. Next slide, please. Okay, this slide is about consideration of assistive technology, and there's a photo of some people at an IEP team meeting, including an individual in a wheelchair. Someone on the team needs to be knowledgeable about assistive technology in order to have a thoughtful discussion about it. What does it mean to consider? It means to think carefully about, according to the American Heritage Dictionary, the IEP team should consider tasks in which the child struggles. Team members will need to know specifically what AT exists to help those types of tasks and where it is available. The IEP team must also identify needed AT services, including training, technical assistance, and supports to school personnel. The team needs to know what those services are and how their school district goes about providing them. Is there a special referral process? A specific contact person? If, in consideration, the team determines that it might be worthwhile to try some form of AT, they need to think about what training or support they, as direct service providers, might need and document how it might be made available. So I want to go over some decision-making strategies that parents may want to consider. That there should be written information for all to see as a result of decisions made about the student or the child. That team members share roles and responsibilities and that those roles are identified. That they consider the student in the environment and the different kinds of tasks that the student might have to carry out. Follow brainstorming rules at that meeting and create a climate of trust. All suggestions are allowed and no judgments passed. Encourage combining, sequencing, and prioritizing the plan of action. Obtain consensus from all participants before adjourning the meeting. And ensure that parent input is considered. Also encourage the involvement of the student if appropriate. think of ways to involve the student and encourage self-advocacy. Next slide.
On this slide, there is a photo of 6 IEP team members sitting at the table. When all of the above factors on this slide are present, the likelihood that appropriate decisions will be made increases. A good IEP team will have a process in place, will come prepared, know when and how or who to contact to assess. Team decisions are made in compliance with IDEA. All children must be considered for assistive technology. Next slide, please. Here are additional quality indicators of effective consideration. The IEP team consideration of any data collected about the students should include 1. In what environments they may require AT. 2. For what tasks would they need AT, meaning assistive technology. The IEP team must include on the IEP the documentation of the need for assistive technology in any area. And also don't forget to consider the needs during extended school year. And what should consideration look like at an IEP meeting? Well, more than checking a box.
So we were finishing discussing what should consideration look like at an IEP meeting. So consider the student progress. Consider that everyone has had a chance for input, and whether there was a thoughtful discussion of the information shared and of the data that was shared. And if it appears that the discussion didn't happen, then somebody at the IEP team can ask questions and prompt the team members for deeper consideration. Next slide, please. 4 outcomes of consideration. So what is the outcome of consideration? If the parent's request for assistive technology is denied, they should receive prior written notice within a reasonable time. If an assessment has been done by the district, parents may disagree and make a request for an independent educational evaluation at district expense. The team also must consider what further assessment, consultation, or screening is needed by an AT specialist before determination of the need for assistive technology can be made. Parents can ask to sign an assessment plan at the IEP team meeting. Next slide.
The photo on this slide of baby blocks with the word goals, and this slide is about IEP goals. IEP goals are based on the present level of performance determined by evaluations conducted, and goals need to be provided in all areas of need. They also need to be specific and measurable in order for the school and the parent to be able to judge whether or not a student is making progress that one expects. Use of assistive technology can be incorporated into the IEP goals to both measure and ensure the services are appropriate and that the student is making progress towards their goals using their technology. The student's IEP must include a description of how the child's progress towards meeting the annual goals will be measured and when periodic reports on the progress that the child is making towards meeting the annual goals will be reported. Now I want to just review some common IEP team mistakes, and unfortunately they happen sometimes. One common error that happens is that assistive technology is considered for students with severe disabilities only. All students must be considered. Another common error is that no one on the IEP team is knowledgeable regarding assistive technology, and that's something parents can ask ahead of time to make sure that the right people are there at the meeting. Another error that's commonly heard about is the team doesn't use a consistent process based on data collection about the student in the environment and using the tasks to make decisions or gather data from the right locations. Another error is consideration of AT limited to those items that the staff are familiar with or team members have available in the district. Another one is that team members might fail to consider access to the curriculum and IEP goals in determining if AT is required in order for the student to receive FAPE. If assistive technology is not needed, a team may fail to document the discussion and refusal on the basis of its decisions. So parents are wise to ask them to read back the notes to see that things are accurately documented in the IEP. I'm going to move to the next slide. The photo on this slide is of two female students of an IEP team at the table, members of the team sitting at the table. The key factor in determining whether a school district is responsible for providing a related service is that you should ask, would this service be required to assist a child with a disability to benefit from special education? In other words, the student must require the service and not simply benefit from it. Next slide. Writing assistive technology into the IEP may be as complex as an automated language communication system or as simple as providing pencil grips to a student. Related services must be written into the IEP if their provision is to be legally binding. Assistive technology can also be a supplementary aid or a related service, or students can have both. Consider what classes a student may require AT in and in what different settings, including home use. Avoid such phrases as services as needed. When a service is being provided as needed, neither the school nor the family will know exactly what to expect from the provision of this service. There is no requirement also for a waiting period, so it's important to talk about and put in writing and into the IEP when the service will begin. On this slide, we show the scope of what an assistive technology service is. And as you can see on the slide, the service could be evaluation, equipment, maintaining, customizing, and replacing equipment, coordinating other therapies, and the use of assistive technology. Parents can request training, technical assistance, or consultation to the staff, or training for other staff supporting the child's educational program. Some types of technology or software require frequent updates, and only staff with administrative privilege can do the update. Address this at the child's IEP team meeting.
On this slide, there's a picture of a school bus. Children could receive special education services in a variety of places. The regular education classroom, special education classroom within the child's neighborhood school, separate school specializing in a specific disability, or some other options. Providing students with assistive technology as a supplement to the child's program may allow the child to be educated with non-disabled peers, or increase the amount of time the student may be in the general education environment. Each student's least restrictive environment is different.
It is the environment where the child can receive an appropriate education while still being educated with students without disabilities. And, in addition, the provision of a free, appropriate public education requires that special education students are involved and make progress in the general education curriculum and toward achievement of their IEP goals. Next slide. IDEA requires the IEP team to consider the aids and services that would help the child participate. Also, to consider how each student will have access to the general curriculum. This part of the IEP meeting is a time in which parents or providers can bring up any assistive technology ideas that may be required by the child. Next slide. You should be familiar with the term Extended School Year Services, or ESY. You should know that Extended School Year Services must be provided only if the child's IEP team determines on an individual basis that the services are necessary for the provision of FAPE to the child. There should be a discussion at your IEP team to consider the need for ESY. Be sure a discussion of AT services and supports are included if required by the student. Next slide.
Here's a photo on this slide of some children sitting in a classroom around a table. So in this slide is about different ways for parents to sign an IEP, or in other words, to give their consent, their informed consent. Parents may consent to the developed IEP and the recommended program, placement, and/or services if the parent fully agrees with the entire contents of the IEP. Parents are wise to read the document before they give their consent. If parents are uncertain about any part, they should alert the other members of the team to their concerns. Parents are not required to sign or give consent at the IEP meeting. Some parents take the IEP home to review and consider before giving their consent or signing an agreement. The IEP services and placement will not begin, or any changes to the IEP will not begin until the parent has given consent. Parents may give partial consent, noting what they withhold consent to. They can request the IEP team have further discussion to resolve those issues, or request another IEP team meeting. In California, if you give a written request for an IEP team meeting, within 30 calendar days, the school district will schedule another meeting. Parents can also choose to deny consent to the IEP or withhold their consent. They may also now, as of 2004, revoke their consent to the IEP. When parents disagree with most or all of the IEP, they can either write a statement to that effect or withhold signing, in which case the district would not be able to carry out anything on the IEP if there's no consent at all. Next slide. This slide is about prior written notice, and it's very important for parents to understand, and professionals as well. This written notice must be given to the parents of a child with a disability a reasonable time before the public agency proposes or refuses to initiate or change the identification, evaluation, or educational placement of a child, or the provision of FAPE to the child. Each of these 7 items listed on the slide are required in this notice, and it's very important for parents to understand this right. Now, there's no specific timeline. The way the federal statute reads is within a reasonable amount of time. So it's something you would receive in writing, probably in the mail, or it'd be sent home in your child's backpack Occasionally, prior written notice is provided at the IEP team meeting, but I'd say that's the exception rather than the rule.
All right, next slide. Communication. On this slide, there's a graphic of two people shaking hands on the slide. The exchange of information can be both verbal and nonverbal. It requires listening, requires the understanding of the message by all parties. How we communicate impacts our relationship with the school. Communication is about listening and talking, understanding the messages given and received. Making communication more complicated is the fact that only 15 to 20% of it is verbal, the rest nonverbal. Know that our body language says things to our listener. Other examples of nonverbal communication or body language include crossing arms, yawning, slouching, and so forth. Most parents desire to maintain a positive relationship with the school staff. Potential areas of conflict include placement, assistive technology, presenting independently obtained information and reports, and denied parent requests. Also, how you phrase your statements can affect how well it is received. For example, using questions during an IEP meeting to find answers is an effective means of communication and participating in the IEP development. So, for example, if the IEP team is reviewing the assessment report and there is vocabulary you don't understand, you may ask a question starting with, "Would you tell me more about," or, "That term blank is unfamiliar to me. Would you please explain it?" If there is something you wish to add to the IEP and you wish to solicit a proposal from the IEP team, you may ask, "What will the school propose to do about," and you would fill in the blank. "How would the child learn to be able to?" So these are just some examples of phrasing your thoughts in the form of a question. And question asking is considered a collaborative communication strategy. Next slide, please.
Now we're going to talk a little bit about parents' procedural safeguards, and actually districts have some too. So the title of the slide kind of speaks for itself, and we put the information a little bit about where you can resolve a complaint or get questions answered. In the state of California, there's a hotline up at the state called Procedural Safeguards Referral Service. So that number is right there to call. It's a toll-free 800 number, and you can call that number Monday through Friday from 9 to 4 p.m. There's some staff there that will get right back to you and attempt to answer your questions. That is also the same agency that handles state compliance complaints. When parents have disagreements related to special education, they have many options to resolve them. They could request another IEP team meeting. Parents can go directly to their special ed director for assistance or call their local parent training and information center like PHP for assistance. Parents could consider filing a state compliance complaint over procedural violations. Or if the issue is regarding Section 504, the Office for Civil Rights handles those kinds of complaints. If the parent wants to, they can request mediation only and attempt to resolve their issues via that way, or they could file for due process to resolve a dispute. We encourage you to talk to your parent training and information, as the staff there have training in how to help families resolve disagreements and resources in the community that may be very helpful. Next slide. This last slide is a listing of resources that can be very useful that are related to the training. The first link is about Section 504 and has frequently asked questions about 504 and the education of children with disabilities. because as you know, students that are eligible for special education are automatically covered under Section 504, so it's useful to learn about, especially in view that the child may continue their education or assert their rights under 504 in a higher education setting like a community college or a publicly funded university or even adult ed setting. The next link is to the AT network, where you can access great information related to your assistive technology rights, as well as archived webinars like this one. The next is the Alliance for Technology Access. And then a few slides actually in the training came from the QUIET, Quality Indicators for Assistive Technology, and that's definitely worth clicking on and taking a look at that site. The next one is the GPAT for the Georgia Project for Assistive Technology. And it will prompt you for a password, but it will open without one. So even if you hit the cancel key, it'll take you to the site. And the rest of the links are added to just enrich your access to additional information that is related to assistive technology and special education. So that kind of rounds up our training. We wanted to leave a little bit of time if anybody had any questions. We have maybe one other thing that might be helpful for you to hear. So this first one, Dianah, why don't you ask that question and I'll go ahead and address it.
Okay, but keep in mind we're going to answer this question first, which is a common question we get asked here at PHP, but we're also going to give you time to draft your questions and post them on the chat if you have any, and we'll move ahead with asking this question. So what is the responsibility of the school district or local education agency for assistive technology devices and services provided by public agencies other than educational agencies?
Well, that's a great question. The school district or the local educational agency is ultimately responsible for providing assistive technology devices and services, but other federal and state laws may require a device or service to be purchased by non-educational agencies. Such agencies cannot abrogate their responsibility even though the child is in school, and IDEA states that the financial responsibility of public non-education agencies, including Medicaid or Medi-Cal and other public insurers, obligate under federal or state law, or assigned responsibility under state policy always takes precedence over financial responsibility of the school district. On the other hand, the school district cannot simply wait for another agency to provide a service, particularly if there's a delay that jeopardizes the receipt of services listed in the child's IEP, thus preventing the provision of a free, appropriate public education. Although IDEA mandates that the chief executive officer of the state, such as the state superintendent of instruction or the commissioner of education, take responsibility for creating agreements among agencies to cover the cost of providing a free, appropriate public education, it also states that the local educational agency or district. So we're going to move on with another question. What is the difference between technology designed for all children or universally designed technology and AT?
So universally designed technology improves the accessibility and usability for all students, with and without disabilities. So for example, an educational web page with text that can be read out loud by a computer can benefit all students who are learning to read. So typically you might find a little icon in one of the corners and down under the tabs, and then you can click on it and then anybody can access that tab and play the audio for that web page or for the story. So AT improves the functional capabilities of an individual child, such as use of this type of communication device. Here's another question. Is my child entitled to use his or her device at home?
I see that someone's writing a message. Do any of the responsibilities entail the IEP crossover into community colleges?
If the child remains eligible for special education, then it would cross over. So say a child used an iPad for some form of communication, and they were placed by the IEP team at the community college site as part of their post-secondary program, or even while they were in high school. Then the IEP team would have to implement the IEP as it's written, and as long as it said that the device was supposed to be available in the community, it would be provided in the community. But once the child ends their eligibility for special education, then the school district no longer is responsible. So that would be either aging out at 22 or earning a regular diploma, and that would end their eligibility. Is there anything else?
It doesn't seem like it. Yeah, it just says, Ricardo says thank you. I was telling people
thank you.
That the webinar will be archived and that PowerPoint will be, people will be able to see the PowerPoint. It takes about a couple of weeks to do that.
Well, thank you so much for inviting us. I really appreciate it. We enjoyed having an opportunity to present this.
No, thank you so much for both of you for presenting on a very important topic. Thank you so much, everyone, and have a good afternoon, the rest of your afternoon, okay? Thank you so much. Bye.
Thank you. Goodbye.